Good morning to all. My name is Donna Bess Frederick, and on behalf of the Chief Labor Officer and staff of the Labor Department, I wish to welcome you all to this presentation on employment leave. For those of you who are joining for the first time, a big welcome to you, and for those who were here yesterday, welcome back. With me this morning are Miss Carol Ann Welch, Labor Officer, and Miss Gail Grant. They'll be assisting with the questions, so we want to invite you to post your questions in the chat, and those two officers will be answering. Also, at the end of the session, I will open the floor so that any further questions can be answered. So let's get started. First of all, we're going to look at our objectives, and we have 3 objectives in mind today. And usually one of the concerns of both employers and employees is in relation to their rights and responsibilities. And we know that with most rights do come responsibilities. So we'll be providing you with an understanding of those rights and responsibilities. Secondly, we want to clarify any misconceptions or doubt concerning which is customer practice and which is actual legislation, and whether an employee is entitled by law to any of these types of leave that we're going to cover. All leave which may be granted to an employee is not enshrined by law, but may be covered under customer practice. So by the end of this presentation, we hope that you'll be more informed on the various types of leave granted to employees. And if this is documented and properly handled, that would eliminate much of the ambiguity and the issues that arise within the working environment. So one of the first types of leave that employees are entitled to is holiday with pay. And this is found under the Holiday with Pay Act. This is covered under the Holiday with Pay Act. Maternity leave is the second one. This is also covered under the Maternity Leave Act. And the employment of Maternity Leave Act and sick leave, which is certified by a medical practitioner, is also covered under the National Insurance and Social Security Act. Another piece of legislation that permits leave is jury duty, and this is covered under the Juries Act. And national duty is another type of leave that is also covered under legislation. You'll find this in the Employment Rights Act. And later on in the presentation, you will hear some more about the kind of activities which are classified as national duty. This next set of leave are those which are not found within legislation, but are normally given by employers, and sometimes are included in the contract of employment or the company's policy manual or in collective agreements. The amount of time given for these types of leave are at the discretion of the employer. So the first piece of legislation we're going to look at is the Holiday with Pay Act. This was enacted in 2017, and the purpose of this act is to provide for holiday with pay to employees. This act repealed and replaced the previous Holiday with Pay Act, which was under Cap 348. And this act, the first one, was enacted sometime back in the 1950s. However, this 2017 was relatively new, and this makes better provision for granting of holiday with pay to employees. One of the main features in this one is that average holiday pay is no longer calculated based on the 126 formula. However, we use 352nd and 452nd as the case applies, depending on the length of service. I will also demonstrate later on in the presentation where other pieces of legislation that are not covered in this presentation seek to complement the Holiday Pay Act. For example, the Employment Rights Act Shops Act, and the Juries Act. So let's look at the definition of an employee, because it is employees that we're dealing with, and these employees who are entitled to their holiday with pay. So an employee means an individual who has entered into or works under, or where employment has ended, worked under a contract of employment. Employee, the definition has the meaning assigned to it by Section 2 of the ERA, Employment Rights Act. And when we speak of a contract of employment, we again refer to the Employment Rights Act, which says that a contract of employment or a contract of, that a contract of service that a contract of employment refers to a contract of service or an apprenticeship, whether it's implied, oral, or if it is expressed, or whether it is in writing. So what makes an employee entitled to holiday with pay? The first factor is continuity. An employee must be continuously employed for a set number of days, as stated by the law, in order to be entitled. And the period of continuous employment of an employee shall begin from and include the first day on which he or she begins to work for an employer. And this also includes any probationary period and shall continue up to the date of his termination of his employment. The point to note here is that Section 4 of the ERA states that holiday with pay or any other leave to which is entitled under any enactment under a contract or agreement binding on him or his employer shall not be treated as an interruption of his continuity of employment. So if a person has holiday or has any other type of leave, sick leave, those things do not interrupt the continuity of a person's employment. Another factor which makes an employee entitled to holiday with pay is the number of days worked. And in this slide, you will see that there are two situations. One where the employee who has worked or who is employed on a weekly, fortnightly, or monthly basis, and that relates to how the payment of the wages or salary are given, whether it's given weekly, every week, or every 2 weeks, or monthly. That person or that employee should work for 208 days in his year of employment in order to qualify. An employee who is employed on an alternative basis where they are paid by the days or the hour or any other method must work for 150 days in their year. So we have those two situations. And I want to also make the point that sometimes we find that persons or employers may have some confusion as to whether a person is weekly or hourly paid. An employee who is paid by the hour, but his or her payments or the wages are given at the end of the week is an hourly paid person. This is different to a person who is paid weekly, and regardless of how many hours they work, they're still paid the same amount every week. So that's the difference between a weekly paid person and an hourly paid person. Another point to note is that if an employee is terminated before the end of his year of employment, that employee can still be entitled to average holiday pay as long as they have a total of 48 working days in 3 consecutive months. So this is the third factor that makes an employee entitled to holiday with pay, and it is covered because it is a statutory obligation. Once they have met the requirements, once they have met the requirements that we discussed earlier, which would be the length of service and the number of days, then the law states that they're entitled. So it becomes a legal obligation of the employer to grant the employee their vacation with pay as long as they meet those requirements that we mentioned earlier. What is a year of employment? Any 12-month period which starts on the day that you are employed is your year of employment. And we also want you to note that this also includes the probationary period. The probationary period is also counted towards continuous employment and should be included when calculating the year of employment, especially for new employees. The start date on which you are employed becomes your anniversary date, and which becomes the marker for future holidays. So in this slide, we'll see how the year for those employees are calculated again. So break it down into 208 days for weekly, fortnightly, or monthly. And for others, especially those who are employed on an hourly or daily basis, it is 150 days. So an employee must complete these two amounts, depending on how he's paid, in order to qualify for his annual holiday. The Holiday with Pay Act offers some provisions, and these include 3 weeks holiday for those persons who have up to 4 years. The first 4 years, you get 3 weeks holiday. And then for those persons who have completed 5 years, it goes up to 5 weeks. And it gets better. If an employee continues to work, they're entitled to 4 weeks. Also, an employee can become entitled to annual holiday, and that holiday can be given in advance of the date of the anniversary. So you may recall earlier that in the earlier slide, we said that an employee becomes entitled on his anniversary date. But if it is that the employer wishes to grant holiday before the anniversary date, that is allowed. The law also provides for the holiday to be given in one period, or if the employer and employer agree, in 2 separate periods. But take note that the employers should keep documentation if it varies from the granting on the anniversary date. Make sure that you have your documentation and records in place so that these can be referred to if necessary. The holiday can also be taken wholly or partly or in advance if the employer and employee so agree. The question may be asked whether, based on the fact that the legislation stipulates a minimum of 3 weeks and a minimum of 4 weeks, whether an employee can be given more than that amount. And the answer is yes. The law says that if it is that it's a part of the contract of employment, or if it is a part of a collective agreement, or if it is employed as a term of the contract, or if it is granted by way of customer practice, meaning that the company has it as their practice within the firm that they would grant more than 3 or 4 weeks, that is allowed. And as we say in the Labor Department, any employer can do better than what the law says. So we see that where it's a part of the contract of employment, part of the collective agreement, and so on, that more than 3 weeks or more than 4 weeks can be granted by the employer. So who determines the commencement date for the employee's holiday? Earlier in the presentation, we spoke of rights and responsibilities and entitlement. In this slide, we'll clearly demonstrate 3 concepts, these 3 concepts. So having established that the employee is entitled to an annual holiday and that it is their right, Section 4.5 of the Act now gives the employer the right to determine the date on which the employee can commence their holiday. So the employer has that right. However, with that right comes a responsibility. The responsibility is that once the holiday is granted, or determination is made that the holiday should be granted, the employer shall give the employee no less than 14 days notice of the holiday. So we have the right, which is that the employer is the one who determines the annual date on which the holiday shall commence. The employer shall determine the date on which the annual holiday shall commence. That is their right. And then we have the responsibility, where the employer shall give 14 days notice of the commencement of that holiday. If this right is not given, the employee has the recourse in that he or she can notify the chief labor officer, and the chief labor officer, if necessary, can refer the matter to the Employment Rights Tribunal. So here we have another case where the Holiday with Pay Act and the Employment Rights Act are correlating. Another provision of the Act is that the employer has 6 months in which to grant the holiday at the time when it is due. So let's say, for example, the holiday is due in June. That is the month that the employee commenced, and that is his anniversary date, his anniversary month. 6 months from there, which will take us down to around December, the employer can use that time frame in which to grant the holiday, or which to give the holiday. So the law gives consideration to the fact that it may not always be possible for an employer to grant holiday on the anniversary date. So by giving a 6 months period from that date, it gives them the window of time, that time frame in which to make their arrangements for holiday. The law also says that if there's a need to postpone the holiday, that both parties, the employer and the employee, must agree in writing. And if it is that happens, that the chief labor officer must be notified, and consent must be granted, should be obtained from the chief labor officer in writing also. The law also provides for the holiday to be increased by 1 day in respect of any public holidays that fall within that holiday. It also sets out how the average pay is to be calculated. And as I said before, where a person has worked for 3 months to 4 years, then the calculation is done by taking their total remuneration or total earnings and dividing it by 52 and multiplying by 3. Average pay, as defined by the legislation, is the sum that an employer pays to an employee for his annual holiday. And it is calculated using the 352nd formula or the 452nd formula, as the case may be. So 5 years or more, when an employee has worked for 5 years or more, the total remuneration is multiplied by 3 and divided by 52, or divided by 52 and multiplied by 3. So total remuneration is the sum paid to an employee in respect of the labor or services performed for his employer under a contract of employment, being the sum of his basic wage. It includes the basic wages, it includes payment for Sundays and public holidays, it includes commission and incentive pay, it includes the cash value or lodging or boarding, and any meals that the employee would have been given and paid for. there's a limit on the amount to be paid for, to be included when the meals are given, and that is $25 a week minimum. And the minimum amount for boarding is $8 per week. The total remuneration does not include discretionary payments of any kind. For example, if you had to pay a person for running an errand or doing something other than outside of their job, and that's discretionary payment, then that is not included in the total remuneration. Now, where it happens that an employee is terminated before his annual holiday, the law also makes provision for that person to be given their average holiday pay. So an employee who has had previous holidays and whose employment becomes terminated, whether they resign or whether they're terminated for cause or laid off, or made redundant, that person is still entitled to their average pay if it is that the termination takes effect before the date of the anniversary. And the employer should pay that person all of his annual holiday average pay that is due to them. If he has already taken part of his holiday and he's terminated, then the remainder of it should be calculated and should be paid to the employee. What happens if a person is terminated after 3 months employment? 3 months means an aggregate of no less than 48 days in 3 consecutive months. The law also makes provision for anyone who's terminated after 3 months of employment and they have not reached a year. We would advise that as long as they have a total of 48 working days in 3 consecutive months, then that person should be entitled to their average holiday pay. And that is also calculated based on the 352nd formula. Yes, average holiday pay and holiday is given at the same time. We would have situations where queries come into us asking whether a person can be given the time, meaning the holiday time, and not be paid. But that is something that we do not encourage. That is in breach of the legislation. The legislation says that a person is entitled to both the holiday pay and the average pay at the same time. And this payment shall be given to the employee no later than the last working day before the commencement of the holiday. Another provision of the Holiday Pay Act is that any notice of termination which is given to the employee immediately prior to or during the holiday shall be void and of no effect. So in other words, an employer should not present a letter of termination to an employee immediately before his holiday or during the holiday. Now, under the legislation, there are also some offenses and there are penalties for those offenses, and we're going to look at those next. One of the offenses under the Act is if an employer refuses to allow an employee to take a holiday. That is an offense, and there is a penalty for that. If, as I said before, the employer fails to pay the holiday pay, that is also an offense. And failing to keep records, this is very important because employees are, under the Act, have the right to visit the Labor Department or call to make lay their concerns or make a complaint regarding holiday pay. So one of the actions that might be taken by the Labor Department is that we would want the employer to produce records so that we can verify whether the claimant's claim is indeed correct And those records assist us in verifying that information. So the responsibility is on the employer to maintain adequate records in case that the need arises where we need to inspect them. So if there is any obstruction or any delaying on the part of the employee for the officer to inspect the records or to examine or to interview in relation to the matter, this is also an offense. And these offenses are, once they are found that it is the person is guilty, subjected to $10,000 or imprisonment for 1 year or both. I think this slide brings us to the end of the Holiday with Pay Act. I'm hoping that you're getting your questions answered by my colleagues in the chat. The next piece of legislation that we're going to deal with is called the Employment of Women Maternity Leave Act. Okay, this legislation is fairly old. This was enacted in 1976, and it is to provide for the grant of maternity leave to female employees and for the protection of those employees during such leave. There's also some correlation between this act and the Employment Rights Act in Section 30, where an employer can be held liable for unfair dismissal if an employee is terminated as a result of her pregnancy or for a reason connected with her pregnancy. Maternity leave actually means leave that is granted to an employee arising from or in contemplation of her confinement, and includes any additional leave granted under Section 5. This additional leave will be further explained. So the features of this legislation are that once a certificate from a medical practitioner is given stating the date of confinement, and once a medical practitioner or midwife gives the actual date of confinement, the first one is the expected date of confinement. The second one is the actual date of confinement, because you should know that these are different. The expected date of confinement is when the medical practitioner expects that the employee will be confined, but then the actual date of confinement is when she actually delivers her baby. So once these are in place, then the employee can be given maternity leave. However, that employee must be employed for at least 12 months prior to requesting that leave. And the term confinement means labor resulting in the issue of a living child, or labor after 28 weeks of pregnancy resulting in the issue of a child, whether alive or dead. The Act also provides for the female to have 12 weeks maternity leave. And that 12 weeks can be 6 weeks prior to, or as she desires, not less than 6 weeks after confinement. And the Act also provides for 6 additional weeks if there is illness arising out of such confinement. And as I said before, in accordance with Section 5 of the Act, an employee who after confinement suffers any illness arising from the confinement shall be granted, in addition to the maternity leave to which she's entitled, additional leave not exceeding 6 weeks as recommended by a medical practitioner. This legislation also grants some protection, as I said earlier, to females who are pregnant. And this protection is given in that they have the right not to be dismissed or given any notice of dismissal between the date of delivery of the certificate and the expiration of the leave. So when the delivery date occurs, and prior to that, the employee has given the employer the certificate between those 2 days, the employee is covered under law and she has a right not to be dismissed. Another protection under the Act is that she is not to be required to resign because she's pregnant, or she should not be dismissed because she is pregnant. She also has the right to be afforded seniority to where the position she was in before she became pregnant, or she was on maternity leave. So on returning to work, she's granted any seniority rights she had before, and she should be reinstated in her former position or given equivalent work. So in other words, an employee cannot be placed in a lower position than what she was working in before she went on maternity leave. There's some limitations to the Act, in terms of the number of pregnancies, the number of maternity, the number of leave of maternity that an employee is entitled to. And it is that an employee is not allowed to have more than 3 occasions of leave from the same employer. It is not to be confused with if you have been working with one employer, you had 3 occasions of leave, and you go to another employer. For the same employer, the law says you cannot have more than 3 occasions of maternity leave. Now, in terms of termination, we said earlier that an employee should not be terminated for pregnancy. However, the law also allows the employer the right to terminate if there has been serious default or gross neglect amounting to abandonment of duty, if the business has ceased to exist. And this is an opportunity that we can, on this occasion where so many employers are closing or have had to lay off persons because of the pandemic, this would be seen as a reason that an employer would be within its right if he had to terminate a person who was pregnant. But the law clearly makes a differentiation between terminating because they're pregnant and terminating for something that happens as a result of the business or as a result of the conduct or the performance of the employee. If the employee has had a term of a contract and that contract ends, or it has an express date where it's a fixed term to be ended, and that employee is pregnant, that would not be held against the employer. So just as how we had offenses in the Holiday with Pay Act, we also have offenses in the Maternity Leave Act, and these are as follows. We go on next to paternity leave, and remember, as I said earlier, this leave is not covered by legislation. However, it can be included as a privilege or granted by the employer in a contract of employment. And we have found that most employers who have included this type of leave in their contracts of employment or in their policies have stipulated that the father or the expectant father must have completed 1 year of employment. And this is similar to the requirement given for the expectant female under the Maternity Leave Act. There must also be evidence of spousal relationship. Again, this is something that we see that the employers may ask for. And unlike the Maternity Leave Act, where it stipulates that the employee or the pregnant female is given a set amount of weeks leave, this leave may be at the discretion of management. But just to be clear, remember that this leave is not currently covered under any legislation. We hope that in the near future we will have this, but at the present it's not. So this is entirely at the discretion of the employer. Another set of leave that employees are entitled to is sick leave, and we have certified sick leave and uncertified sick leave, and then what is custom and practice. So uncertified sick leave is when a person just calls in sick, say they're not feeling well, call the employer not feeling well. It is not accompanied by, or it's not required to be accompanied by a medical certificate. And usually the person would call and that is noted by the employer. However, it is expected that if a person calls and is sick for one day, that the number of days that are called in as uncertified sick days should not exceed 2. If it is that the person remains sick on the 3rd day, it is required that that person should submit a certified sick document from a medical practitioner, what we call the sick certificate. If it is that the employee cannot produce the paper, is unable to reach the workplace because they are, not able to leave home, the workplace should be notified. The doctor's certificate should include the date of the doctor's visit and the period of the leave, and also should include the date that they're due to return to work. Employees have the right to privacy, and the medical practitioner is not obligated to disclose the nature of the illness. As I said before, the ERA, or the Employment Rights Act, makes provisions for areas that fall under leave. And in this regard, again, if an employee is dismissed because they are sick, the Employment Rights Act gives them the right to claim unfair dismissal. And there are 2 conditions. If the sick leave was for not more than 12 consecutive months, or periods amounted to 12 months in 24 consecutive months, and during that time the person was dismissed, then the employer would be in breach of the Employment Rights Act, and the employee can claim unfair dismissal. The question might be asked as to how much paid sick leave should an employee be given. Employers are not required to pay employees when they're on sick leave. Persons have the benefit of being reimbursed through the National Insurance Scheme. However, if it is that an employer is willing to pay an employee while they're sick, then those number of days that the employee will be paid for should be stipulated within the employee's statement of particulars or the contract or any collective agreements that they have. And for example, some companies may have 6 weeks certified sick leave, 3 at full pay, 3 at half pay. However, they may also have the condition that once the person is paid from the NAS, that those checks from the NAS will be handed over to the employer. National duty. As we said before, this is also a kind of leave that is granted to the employer, can be granted to the employee on request, and this is covered under the legislation as well. If an employee is a avid athlete and they participate in a sporting event, once the requisite documents are produced, the employer can give the employee time off to attend any sporting event where they have to represent the country locally or internationally. Employees who belong to nonprofit organizations such as the Girl Guides, Boy Scouts Association, the Cadet Corps, the Barbados Defense Force, or the St. John Ambulance Brigade, those persons are also entitled to have time off if it is that they're required to do so for those organizations. And this is also covered under the Employment Rights Act. Another area in which persons can have leave is if they are a volunteer in an emergency situation. If they're a member of the DEO, District Emergency Organization, and we have a natural disaster, those persons should be allowed to have time off to perform the duties that they're required for those organizations. We also mentioned that persons who are called by the court to attend to juries will be able to do so under the Juries Act. And the Juries Act stipulates that the persons, once they are attending court, should receive their basic wages while on duty. When not sitting on a case, they should report for work. And an employee should not be dismissed for attending jury duty. This next piece of leave, or kind of leave, is not covered by legislation. And this is where an employee may have had a death in the family or a close relative and requires time to be able to attend to the funeral arrangements and so on for the deceased. Again, employers can stipulate whether this is agreed to in the contract of employment, and it may also be found in collective agreements. Usually, the case is looked at on a case-by-case basis, and usually, if it is a mother, a father, spouse, or child, the person will be granted 3 days. This is not set. Again, it can vary. It's at the discretion of the employer. And it may also be looked at in relation to the relationship of the deceased to the employee who's requesting the leave. For example, it may not have been a mother or father, but the deceased may have been someone who raised them, who would be just as close as their mother or father. So you would look at that and use your discretion in granting the required time. Another set of leave that is not covered by law, but may also be included in the employee's particulars or the contract of employment or the collective agreement, is study leave. Now, proponents of this leave suggest that given an employee study leave increases employee engagement, and we can see why. It will also serve to reduce absenteeism, and it is given at the discretion of the employer. Again, as I said before, it is not legislative. However, you may want to look at the fact whether the person is studying a regular degree or a bachelor's or a doctorate or master's, in helping you decide the amount of time that would be granted. And finally, paid or unpaid personal leave. There are times when an employee may require special leave to attend to personal matters, and this can be discussed. We encourage that this should be discussed between the two parties, and this can be granted at the employer's discretion. Again, this kind of leave is not covered under the law. So we've come to the end of the presentation. I hope that you have been able to capture something that would help you in looking at the way leave is treated within your organizations. And I also, at this point in time, would want to open the floor for questions. I see a hand raised by Michelle Arthur. Yes, Ms. Arthur. Good morning to you.
Good morning. I have a question about leave as it relates to, I know there's something in the Employment Rights Act which speaks to if you have to take care of a relative. And I didn't see that mentioned in specific terms. So I'm wondering what would that relate to in terms of the information that you've given? Where would I find that covered?
Okay, I will shortly address that. Is there any other questions while I look for this information? Are there any other questions that we can look at as well? Thank you for your question, Michelle.
You're welcome.
Okay, the section that you're referring to is section 30, which speaks of the contravention of the right of an employee to be unfairly dismissed. And it says that the responsibility of the employee for the care and welfare of a dependent family member or child with a disability who is under the immediate control of the employee, being a responsibility associated with an emergency affecting the child or dependent family member with a disability, that person should not be terminated if that is the reason for the leave. Michelle, does that answer your question?
Well,
I'm not hearing you.
And that, but one has to be hospitalized, and you're required to be there to do that. Where in the leave or in custom and practice or whatever, because you're supposed to things be covered. If it's in the Employment Rights Act at Section 30, where would I be able to quote that leave if I have to say to my employee, well, I have an emergency, I'm not sure how long it's going to take, it could be, where would I be covered?
I'm not hearing everything that you said, but the gist of it is that you're asking if the family member is hospitalized and you have to take time off from work to deal with that situation, how would you be able to represent that by looking at what the act says? Is that your question?
Yes, that is my question. Where would I be able to say if the person is hospitalized, say in intensive care, and you're required to be there to make decisions for that person, and it is protracted, say the person is on life support or very really seriously ill, and you have to be there, and you're not sure even of the time period that you'll be required to be there, and your employer says to you, you have been gone now for 3 days. You don't have any vacation leave. You don't have any certified sick leave that you can take. What then can you say to the employer regarding that situation?
Would you have, you say you don't have any vacation left, you don't have any other time left. What about, would your contract be, would the contents of your contract have anything in it relating to personal leave?
But I'm not sure. That's what I'm saying. What can I quote, or what kind of discussion can I have to say that this is what is going on? Because it says in the Employment Rights Act that you cannot be dismissed for that. Well, it
It's,
constitute unfair
but
dismissal.
it speaks more specifically to a child or dependent family member with a disability.
Mm-hmm.
However, we, as I said before, we always encourage the employer to do better than what the law says. I mean,
Exactly.
I fail to see that if you have a child or dependent family member in hospital and intensive care, that an employer would be so harsh as to not be considerate and discuss with you to see how they can work it out.
Mhm.
So there must be some discussion involved. If it is not covered under anything specific, then you can have a discussion with the employer to see how that can be arranged.
I
I don't-
I asked this because it had happened to me previously and to two other people that I know, and I was told that I had to take non-paid leave, and that was problematic, and it was difficult,
Mhm.
obviously. So that's why I asked what provisions are there, if any, or
Mhm.
where it would be allowable. But I know it's not specified by law. I recognize that, having gone through this exercise with you this morning. But there are
Mhm.
times that these situations come up.
Mhm.
What I was just asking. Okay, thank you though.
Okay. You're welcome. Are there any more questions? Not here. Are there any more concerns or questions based on what we presented this morning? Okay. I see Kathy and Ali. Go ahead with your question, ma'am. Good morning.
Hi, morning.
Morning.
Okay, so your colleague I had asked, can the employer stipulate when an employee could take holiday during a year? And your colleague has said yes. The employee makes the request, but the employers make the decision when the holiday will be granted.
Correct.
So, can the employer to stipulate then how much time to that you can take at any one time? So suppose you
And
are allowed the 4 weeks, and can the employer stipulate and say, well, you can only take 2 weeks this time and 2 weeks then another time?
the law allows for there to be, for the holiday to be taken in two parts, but it also stipulates that it must be by agreement by both parties. So in that case, if an employer is requesting that you take it in two parts, it must be by agreement also with the employee. because the law clearly allows that you have 3 weeks at any one time and 4 weeks, whichever applies to you for your length of service. But if it is that either party wants to have it separated in 2 sections, it must be by agreement by both parties.
Okay. All right. So wait, so last question. So if I am not in agreement, what do I do? Or I must just accept then what the employer says?
Well, the law is on your side and saying that it must be by agreement. So if it is not by agreement, then you must be able to take the full amount that you're requesting.
Okay. All right. All right. Thank you.
You're welcome. Any more questions?
Sick leave and vacation. That's a question that come up.
Okay. One of the questions that has been submitted via the chat is whether an employee can be on 2 leaves at the same time. And I was told it's in reference to vacation and sick leave. Now, there's a case of which comes first, the chicken or the egg. If an employee was on vacation and they took ill during that time, requiring them to be on certified sick leave, then they're already on vacation and the vacation is already taken, right? The vacation continues. It's just unfortunate that the sick leave happened while they're on vacation. Some employers, however, may consider, if the employer approaches them and have a discussion, may consider, as I said before, we can always look back and know what the law says. The employer can consider postponing the vacation until the person recovers, but that's at the discretion of the employer. There's another scenario where the employee might have applied for vacation or being granted vacation, and let's say the day before they were supposed to go on vacation, they took ill. In that scenario, the sick leave commenced first, so the sick leave is what they will be on, and the vacation will be suspended. So a person cannot be on 2 leaves at the same time. The one that started first is the one that will be continuing. But as I said before, it is good to have discussion on these things, for the parties to discuss these things and see whether they can come up with something that is amenable to both parties. I see a question from Suzanne Barker Small. Ms. Small?
Yes, good afternoon. There was an electricity shortage during your presentation on holiday pay. And
Yes, sorry about that.
yes, the electricity went off in my area.
Oh,
And
okay.
so
That's why we had these flashing lights in here.
yes, so I did not hear what you said about the average holiday pay and the normal holiday pay and the difference between those and how they are applied. So if you can repeat that for me, please, including the calculation, I would appreciate it.
Average holiday pay. Let me see if we can find that screen now. So it's Suzanne, is it?
Yes,
What's
it
your name?
is.
Suzanne. Can you tell me which one you were slightly referring to? Is it this one?
I did not see those. The last thing I saw was the 208 and the 150 screen.
Oh, okay. This one.
That one, yes, that's the
Right.
last one.
So the question is, how is this applied?
What's the difference between the average pay and the normal, sorry, the average holiday pay and the normal holiday pay? And how are
What do
they?
you call normal holiday pay? Let me understand what you mean.
Well, when I read the Q&A, I
Mhm.
saw Miss Welch answer somebody in those terms. So I said, okay, well, I guess I missed information when the person was speaking about normal holiday pay and average holiday pay. So
Okay.
that's what.
I'm not sure what Miss Welch would have been answering, but
So
but
if you can just
yeah.
continue from here, just to explain the holiday pay section, then that would assist.
Miss Welch is going to clarify it for you because I
Okay,
wasn't
thank
privy to
you.
the question that was raised. Thank you.
Okay, all right. Okay. Hello?
Have you any more questions?
Right. I was saying that you could just then explain the calculation for the holiday pay then.
Okay. So if you are an employee and you have worked for up to 4 years or under 5 years, your holiday pay is calculated.
Good morning to all. However, by definition, holiday pay is, you can hear me, Donna?
Yes, I can hear you. I can hear you, Caroline. I'm going to mute my mic so you can answer the question.
Okay. Now, when we think of average holiday pay, we normally use that term in the instance of persons who would have worked less than a year. And
Oh, okay.
right.
Okay.
So it's basically the same thing because it's calculated in the same manner.
Okay, so if you work for less than a year, then you're taking the total work during that period and dividing it by 52 and multiplying by 3 the same way?
Yes. So it's the same
Okay.
calculation.
Oh, I saw it was a different calculation
No,
because I went back in the Q&A and it was actually Caroline Welch that answered somebody else speaking about regular holiday and average holiday. So having missed that section, that's why I was confused.
no problem. But you're
Okay.
also free to contact us. Ms. Beth Frederick would share the contact information at the end of the presentation. And we will
Okay,
also
thank
post
you.
it in the chat.
Thank you.
Okay. All right.
Another question we have here is whether an employee can continue working during their holiday and be paid for both holiday and
No, you can't work during holidays.
okay. As I said before, an employee should be given both holiday and pay at the same time. If it is that the employee is asked to return to work during any time of the holiday, we recommend that that person be paid at a overtime rate for that time that is spent at work during the course of the holiday. But you cannot continue working during your holiday and be paid for both holiday and work. I have a question from Carolyn Colcross. Good morning.
My question is, how would you now treat persons who ask for time off because the child has these different days that they're not attending school? And obviously at work, you might not be able to bring the child to work. The work is not conducive for a child, and the person will have to stay. There's no person to keep the child. So the person has to stay home to take care of the child because of what's going on now. How would you treat that?
When you say what's going on now, I believe you mean the impact of the COVID-19 pandemic?
Yes, yes, please.
Right. Your question is a very interesting one. It's something question that we would have had many calls about within recent times. And COVID has not only affected most aspects of life as we know it. If anybody can tell me some aspect of life that COVID has not affected, I'll be happy to hear them. Even when it comes to holiday, granting of holiday, COVID-19 has affected that because, you know, there are persons whose holiday, and we'll get to your question, Ms. Coltrane, the persons whose annual holiday would have been due like around this time, but because they may have been on layoff for 22 weeks, 26 weeks, that would have affected the amount of days that they would have been working, therefore placing the granting of holiday in some question. But to answer your question, that discussion is something that needs to take place between both the employer and the employee. The law does not cover every situation that can arise, and this is one of them. So we would encourage that both parties have a discussion, look to see where they can meet each other halfway. And even in terms of the question of whether the person can adequately work from at home, it may not always be possible, but I mean, these are times that we need to look at all alternatives to see where we can still collaborate, where we can still work together, where we can still work, and where we can still make a living. So that's something that we would encourage both parties to look at. Your situation, you're asking what the employer can do if the employee is required to be at home with a child who would not be attending school every day. I can see that the employee may also be impacted even if you ask them to utilize some of the vacation days, because if that person would have been off, might have been off for a long time, they might have less time available. And if anybody is out there who has heard the question, can you tell us some of the alternative arrangements or suggestions that you as an employer have put in place so that we can assist other persons who have similar concerns? Are there any persons who have been faced with this situation and have dealt with it in a different way? Is it Carrie Ann? Is there with a question or a response? Carrie Ann?
Hi, yes, I was going to give a response. What we've been doing is that we've allowed persons to be able to work remotely from home, so they won't come into the office physically, and they're allowed to stay on the days that their children are going to be at home with their children. So they can't come into the office physically, but they are still allowed to operate from a remote location.
Okay. Thank you, Carrie Ann. So I don't know if this suggestion that Carrie Ann made is suitable to Carolyn, but Carolyn, you can let us know.
Yes, that is good. But what about right, that is an alternative, but as I would have heard on many occasions, the child, there's one computer and the child has to do work from the teacher is still sending work and it has to be submitted at a particular time. So it would have been clashing with the person's work and the child's work. So trying to ensure that everybody's satisfied might be deemed as kind of difficult. Or if suppose the person is um, a cashier, they can't work remotely from home, then what would happen there?
Okay. The first scenario where the employee has to juggle, you would want to call it, juggle time to be able to help the child and so on. That's really something that the employee will have to take responsibility of, because it would be unfair to expect the employer to have to bend over backwards, as we put it, in every situation to allow the employee to be at home. It has to be a meeting point of two parties. It has to be consideration given to the employer as well. So I would say that for that first part of your question, where the employee is concerned about having to deal with the commitments of the child in terms of the studies, that's something the employee will definitely have to look at and look at all options that can be considered in that regard. But as I said before, a lot of these things that are happening, these issues that are coming out, are not covered by law. And we would encourage dialogue between the parties to see how best they can deal with the situation. A question that we just had coming in is whether in the event that an employee is needed back at work during the holiday, is it lawful for the employer and employee to suspend the holiday and defer the remainder until a later date, given the requirement of 14 days? Now, the Holiday with Pay Act stipulates that an employee should be given their annual holiday, and that it also stipulates that if the holiday is supposed to be suspended, and that is before it has started or postponed, that the chief labor officer should be written and consent should be obtained. But there's a different scenario here. This is where the employee is already on holiday and the employer is requiring them to be at work. Now, I would say that it would be left up to the employee to decide whether they want to break the holiday to go into work because they're already on holiday, and it would be seen as overtime, and overtime is not compulsory. So it's left up to the employee to decide whether they are willing to go back to work during their holiday. Because legally speaking, they are entitled to the holiday and we're already on the holiday. But if it is that they decide, they make the decision to go in while they're on holiday, and the decision is further made to suspend the holiday, whatever decision is made should be put in writing, and both parties should be in agreement to this agreement, or whatever decision or whatever arrangement is made. Michelle, do you have a further question? I see your hand is up.
Yes, I do.
Go
I know
ahead.
there have been situations where people have gone on vacation and then taken sick leave and applied for a payment from national insurance. I just want to know if that is illegal, because the arguments you get sometimes from employees suggest there's nothing wrong with it, but to me it's being paid twice.
So you're referring to an employee who has been paid vacation pay, paid holiday pay, is on
Yes.
holiday,
Yes.
different holiday and is then submits a certified certificate from the doctor, and they also receive sickness benefit for that period from NAS.
Yes.
Referring to that. Um,
Is that illegal?
this would mean that the NS department would have to make determination if the person will be paid for the period of sick leave. While a person is on vacation or holiday, still employed, and the deductions from the vacation pay would have gone into NS also. So would your company or the company you're referring to have a policy in that the payments that are made from the NS be turned into the employer? Because that's usually what happens.
Well,
That you don't, you so that you
this
don't, you're
company,
not supposed to receive payment from the workplace as well as payment from NS at the same time.
well, funny enough, this company was not up to date with their NAS payments or with the submission of their schedules.
Okay. So then what?
So the employee was saying they don't pay any NAS for me, and I could afford to apply for the NAS benefit, although they would have been paid from the company for the vacation.
So if they're not paying the NAS benefit on time, how did the employee receive the benefit from NAS? Because if they're not paying on time, that would affect the employee receiving the benefit. So
As the officer,
something isn't clear there.
eh, uh, then I spoke to the person who was responsible for that area. The person said that the company, that the NAS was still paying the benefits, even though that they didn't have those things yet, because they are aware that there's some companies, they will go after the individual schedules, but they will still pay until the schedules came in. So there's still a disconnect between um, getting the information from companies and also that payment of NAS, because apparently NAS that has not been saying, well, we haven't seen the schedule, so we're not going to pay you X, Y, or Z. They've still been doing it.
Oh,
And I think it would
that
be
is an
more
unusual
challenging
one.
now with COVID.
That is an unusual situation because I am not aware. Usually the case is if the employer has not paid the contributions and the employee goes to make a claim, it is usually the case that the employee does not receive a benefit. So to find that an employer is not paying the contributions and the employee still receives the benefit, that's new to me. But and it is very new to me, and is a question that I would have to suggest that you speak to NAS about, because that's out of our realm. It's not covered. NAS contributions are not really covered under our legislation, nor the benefits. So, it may be best that we get somebody from NAS to answer that question, or you can call the NAS about that one.
Okay, thank you very much.
You're welcome. Are there any more questions? Okay, just for just for information, for those who want to contact me after the end of the session, the telephone number to contact me would be 535-1508, or alternatively, you can contact me by cell phone at 832-0538. Do we have any more questions? Okay, it seems that we don't have any further questions. So I just want to thank everyone for attending today's presentation. And I hope you're looking forward to tomorrow's presentation as well. And we will leave the chat open for any other questions that may be being dealt with now by my colleagues. And I want to wish you all the best for the rest of the day and look forward to meeting with you again tomorrow. Thank you for being here and do have a good day.
We can dream because there is where it all begins, with a step, knowing we can do it. See the light, it's time to realize our potential to grow, to be whatever we dream. Focus on our goals, to be the winners with science and technology. Together we can go far. Pride and industry, that's our motto. So getting qualified, we can go far. We've got skills, we can compete, develop, train, innovate. Come on.